Welcome back. We continue with the CPC topic. Now we will go to the next section. Section 86. Suits against foreign rulers, ambassadors and envoys. We have already seen that they can be sued in their personal capacity but not in their official capacity. They have certain privileges also, right? Special privileges. Therefore, it is not that easy that we can just go and file a case against all these envoys and ambassadors and other country rulers. Okay, so in that case, what has to happen? Again, application has to be filed before the central government, and permission has to be taken from the central government of India. Okay, it has to be taken from government of India, saying that I wish to sue so and so person in his official capacity. Clear? Except where a tenant of an immovable property shall without consent as aforesaid, from whom he holds or claims to hold the property. So, if a person is a tenant, then he can file a case. There is no need of central government permission. But other than that, central government permission is necessary. And when will the central government give the permission? You can just go through the conditions there. If the foreign state has instituted a suit in the court against the person desiring to sue, a citizen of India, wishes to sue the foreign state. But instead, before he could sue, the foreign state has sued the person. Clear? So, in that case, central government can give permission. By itself or another, trades within the local limits of the jurisdiction of the court. If the foreign state conducts any trade, then on that matter of trade, cases can be filed. That's not a problem. Then, foreign state is in possession of immovable property situate within those limits and is to be sued with reference to such property or for money charged thereon. See, these are all seeming to be in personal capacity. Am I right? Even though it is a foreign state which is carrying on trade with the within the jurisdiction of this country, or where the foreign state is in possession of immovable property. Okay. Actually, it is, see, if it is within the time period or whatever, as we have seen, owner and tenant and all those things, then it can be if the tenancy is still going on or if the lease is still going on, then we cannot. But otherwise, case can be filed against the foreign state. Foreign state has expressly or impliedly waived the privilege accorded to it by this section. Where the foreign state says, okay, it waives. Waives means what? It says, okay, I don't want it. Okay. So, waives. It waives the privilege given to it by the government. Then, except with the consent of the central government, certified in writing by a secretary to that government, no decree shall be executed against the property of any foreign state. We have already read this in the previous section. Am I right? So, same thing. Except with the consent of the central government, certified in writing by a secretary, no decree shall be executed against the property of any foreign state. So, execution will not happen. We read it when we were doing about the central government and the state government and public officers. Am I right? So, this also comes in the similar capacity. Though it is a foreign state and foreign state ruler and all those things, it comes within similar capacity. The fourth point, the preceding provisions of this section shall apply in relation to any ruler, any ambassador, any high commissioner, any envoy. Okay. Then fifth point, the following person shall not be arrested under this code. Who are all? Ruler of a foreign state, ambassador or envoy of a foreign state, any high commissioner of a commonwealth country, any such member of the staff of the foreign state or staff or retinue of the ruler, ambassador or envoy of a foreign state, or of the high commissioner of a commonwealth country, as the central government may by general or special order specify in this behalf. So, who all cannot be arrested? Any ruler of a foreign state. Okay. Then, um, uh, the ambassador or envoy of a foreign state, high commissioner of a commonwealth country, or any staff of the foreign state, or any person of the retinue. Retinue means what? Behind the ruler. Behind the ruler, we have seen in movies, no? King will be there, behind him so many ministers, soldiers, so many people will be there, right? So all these people are now known as the retinue. Okay, so retinue of any ruler. They cannot be arrested except with the special order or general order of the government. Clear? Then, sixth point, where a request is made to the central government for grant of any consent referred to in subsection 1, the central government shall, before refusing to accede to the request in whole or in part, give to the person a reasonable opportunity of being heard. So, what is there in subsection 1? Nobody can be, no case can be filed against the foreign state, right? Ruler or high commissioner or envoy of any foreign state. So, only if the central government gives permission, the suit can be filed. Section 87, style of foreign rulers as parties to suit. The ruler of a foreign state may sue and shall be sued in the name of his state. When we say style means what? The manner in which he shall be addressed. Okay, so it shall be in the name of his state, provided that in giving consent referred to in section 86, central government may direct that the ruler may be sued in the name of an agent or any other name. So how will usually the case be filed? It will be filed in the name of the state. See, you don't have to go to foreign countries in order to know all these things. When we file a case against the government itself, okay, or any public officer of the government, we don't say, unless it is only the public officer, the only person who has committed it. Other than that, we say state of Karnataka, state of Andhra, state of Rajasthan. This is how we speak. Am I right? Okay. So that is what it is. When it comes to foreign rulers also, he shall be sued and he shall sue both ways. He shall sue and be sued in the name of his state. Unless otherwise, the central government gives its consent saying that the ruler may sue or be sued against in the name of his agent or in any other name. If the ruler says, no, I don't want to be sued in the name of the state, please take the name of my agent, or maybe some other name he gives. In that case, he or she, whoever it is, okay? So, in that case, the person whose name is given shall be used for the purpose of suing and be sued against, okay? Then, section 87A, definitions of foreign state and foreign ruler, okay? Foreign state means any state outside India which has been recognized by the central government. Underline. Recognized by the central government. Underline. Okay, because there are many countries and states. When you read the constitution or when you're reading civics in your school or whatever it is, we get to know that nations have to be recognized in order to carry on with the trade and public relations, right? So, some countries, they may be existing, but they are not recognized. So, therefore, they are not taken to be one of the countries with whom trade can happen, right? So, foreign state means any state outside India which has been recognized by the central government. And ruler in relation to a foreign state means the person who is for the time being recognized by the central government to be the head of the state. Ruler does not necessarily mean a king or a queen or whatever it is. Okay, it can be the president, it can be the prime minister, anybody. Every court shall take judicial notice of the fact that a state has or has not been recognized by the central government. Number 2, that a person has or has not been recognized to be the head of the state. So, obviously, only if the nation is recognized, okay, ruler will be recognized. Sometimes what? Nation will be recognized as a nation. But the ruler who is in place may not be recognized by the central government as the ruler. For various facts, sometimes it may be because the person came up through coup. I hope you know what is a coup. Coup means military superiority. Okay, they take over a government. Okay, sometimes it may be because of military coup or it may be because of anything else. Okay, so the ruler as such shall not be recognized by the central government. So in these cases, they don't come under the category of foreign state and ruler. Section 87B, application of sections 85 and 86 to rulers of former Indian states. Okay, in the case of any suit by or against the ruler of any former Indian state, which is based wholly or in part upon a cause of action which arose before the commencement of the constitution, or any proceeding arising out of such suit, the provisions of section 85 and subsection 1 and 3 of 86 shall apply in relation to such ruler as they apply in relation to the foreign state. So they should be recognized by the central government of India to be rulers. Provided what? It cannot be that, okay, my great grandfathers were rulers, so I come from that dynasty, so I am also a ruler. It's not like that. Understand? The ruler has to be recognized by the central government. One more main thing for the person to carry on with the case, the case should have been instituted, the suit should have been instituted before the framing of the constitution. Clear? Am I right? Before the commencement of the constitution. Why is it commencement of the constitution? Because if it is in the drafting stage or if it has not been passed, then there is no confusion. Am I right? So the suit should have been instituted before the constitution, or the suit which is being filed now should be in relation to the suit which was filed before the commencement of the constitution. And one more point is, the ruler of any former Indian state should be recognized by the central government to be a ruler. Understand? Just like that, they cannot go on saying, I am a ruler, I have every right. This is not the way. Okay? Then, former Indian state. What do you mean by former Indian state? Means any such Indian state as the central government by notification in the official gazette specified to be former Indian state. Why is it very important? Okay, see, this may look very simple. Why is she explaining so much? But why you should know this is because if any question arises as to what is a former Indian state, you cannot say a state which was existing before the constitution, because before the constitution came into existence, it was not like it was divided into state or anything. Everything was in a hodgepodge. Probably some ruler from Kashmir had already occupied Karnataka. For them, distance was not a big thing. They used to come occupy so many territories and go back, right? So we cannot call, just because Jammu Kashmir occupied Bangalore, I'm just giving you an example, Karnataka, you cannot say the ruler of Jammu Kashmir is also Kashmir and Karnataka are one state. It cannot be. Am I right? So that is how it is within the territory. That's all. It is not a state as such. Clear? So when it comes to former Indian states, only those which are recognized as former Indian states by the central government. Okay? Only those can be treated as former Indian states. Commencement of the constitution means 26th day of January 1950. We know it very well. Clear? Then next one, we go to the next subheading, interpleader, section 88, where interpleader suit may be instituted. Where two or more persons claim adversely to one another the same debt. Underline the word adversely. Underline the words same debt. Adversely, same debt. Okay? Sum of money or other property, movable or immovable, from another person who claims no interest. Underline, no interest. Claims no interest. Another person who claims no interest therein other than for charges or costs, and who is ready to pay or deliver it to the rightful claimant Such other person may institute a suit for interpleader against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made and of obtaining indemnity for himself, provided that where any suit is pending in which the rights of all parties can properly be decided, no such suit of interpleader shall be instituted. See, where there is a confusion, to put it in very simple words, where there is a confusion as to whom the property belongs, to whom it should go to, whether it is movable property or immovable property, wherever there is a confusion as to who is the rightful claimant over it, then interpleader suits can be filed. But where there is a very clear distinction as to who is the rightful claimant of the property or the money, movable property or money, then no interpleader suit can be filed. It is as simple as that, okay? Then next we go to part 5, special proceedings. First one, under that we have the subheading arbitration. Section 89, settlement of disputes outside the court. We know of settlement of disputes inside the court, right? Outside the court, how does it happen? Where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, their court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration, conciliation, judicial settlement including settlement through Lok Adalat or mediation. Okay, so these are the 4 bodies which deal with settlement of disputes. Okay, so how to put it in simple words, I'll just tell you. Case has to be filed before the court, and the court can issue, see, suppose I file a case before the court and say that my client wants to settle the matter, Your Honor, he doesn't want to go through the court. Then upon my application, the court will refer the matter to arbitration or conciliation or judicial settlement, that is Lok Adalat or mediation. Clear? Once the court does this, then I will have to approach only these and then take up the matter for settlement. Okay. Okay. Number 2, where a dispute has been referred for arbitration or conciliation, obviously, where it is referred for arbitration or conciliation, Arbitration and Conciliation Act. Where it is referred to the Lok Adalat, then it will be in accordance with the Legal Services Authority Act. Am I right? Lok Adalat is Legal Services Authority Act. It gives a variety of provisions. Okay, in that Lok Adalat is also included. Therefore, it goes under that act. For judicial settlement, the court shall refer the same to a suitable institution or person who shall be deemed to be a Lok Adalat, and all the provisions of Legal Services Authority Act. See, it can be, when we say Lok Adalat, it can be a single person or maybe a group of people, 2-3 people together, something like that. Okay. Then, for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. For mediation, it is the court itself. They'll tell, both of you sit together and talk, we will see. Okay, so for mediation, it is like that. So we have the mediation centers also, which we can approach, no problem. Okay, then next one, next subsection, subheading, special case. Section 90, power to state case for opinion of the court. Section 90, where any persons agree in writing to state a case for opinion of the court, then the court shall try and determine the same in the manner prescribed. Clear? So, where there is it is a statement of opinion of the court, means where we file a suit and say, no, what do you feel? Okay, what do you feel means what? The court has to take an action, right? The court has to decide the matter. Clear? So, power to state cases for opinion of the court. Whenever we have a particular, a particular question to be answered by the court. Then we state it for opinion. The next subheading, public nuisance and other wrongful acts affecting the public. What's public nuisance? Section 91. In the case of a public nuisance or other wrongful act affecting or likely to affect the public, a suit for declaration and injunction or for such other relief as may be appropriate in the circumstances of the case be instituted by the Advocate General or with the leave of the court by two or more persons, even though no special damage has been caused. So when can public nuisance? See, public nuisance we already know it's there in IPC, right? But when it comes to stay civil cases, can case be filed for public nuisance? Yes, it can be filed for public nuisance. A case can be filed by whom? By the Advocate General or with the leave of the court any two or more persons. Any two or more persons, even though no special damage has been caused. That's why you have the sound pollution, air pollution, you have all these cases in the court only because of that. I think you must be aware of National Green Tribunal, am I right? NGT. Okay? All these were formed out of this. We have something called the Environment Protection Act, am I right? So, when you are studying for your judicial services, just keep everything in mind so that it will be easy for you to follow. You don't have to be thorough with all the acts. I'm not asking you for all that. What I'm saying is you just have an idea about various acts so that when you're reading, you will exactly know how to put across your points. That's it. See, for exams, what we do is we have to write whatever is given here. We have no other go. But in Viva, when they are asking questions, probably you may need all these things. Clear? So just keep an open mind, keep an idea about everything in your mind so that you can do your Viva well. Okay? So, nothing in this section shall be deemed to limit or otherwise affect any right of suit which may exist independently of its provisions. Okay? So, any other provisions are there and we have to go only by those provisions. Say, there are some acts. In that case, we cannot go via CPC. For example, you have the pollution and all that. You cannot go to a civil court with the pollution case. You have to go to National Green Tribunal. Right? So, there are specific things for which you have to go to specific ones. Then, Section 92, Public Charities. In the case of any alleged breach of any expenses or constructive trust created for public purposes of a charitable or religious nature, or where the direction of the court is deemed necessary for administration of any such trust, the Advocate General or two or more persons having an interest in the trust and having obtained the leave of the court may institute a suit, whether contentious or not, in the principal court of original jurisdiction or in any other court empowered in that behalf by the state government within the local limits of whose jurisdiction the whole or any part of the subject matter is situate. So what does this say? Public charities, when it comes to public charities, either the Advocate General, public charities, remember that, not private trust. Public charities, the Advocate General can file a case or two or more persons who have an interest in the trust can file a case. Okay, provided they take the permission of the government. Then for what? To obtain a decree removing any trustee. So what are the topics? Clear? So for removing any trustee, they can file a suit. For appointing a new trustee, it's a public charitable trust. Always remember that in mind. Okay, for removing any trustee, for appointing a new trustee, for vesting any property in a trustee, directing a trustee who has been removed or a person who has ceased to be a trustee to deliver possession of any trust property in the possession of the person entitled to possession of such property. See, it can either remove any trustees or appoint any trustees, or where some existing trustee who was existing has a trust property in possession, then it has to be given back to the trust. Then fourth one, directing accounts and inquiries. Okay, wherever there is a need for, say for example, settlement of accounts and all those things, for going through the account statement and all that. Then directing accounts and inquiries. Then deferring what proportion of the trust property or of the interest therein shall be allocated to any particular object of the trust. Okay, so if there is a dispute regarding the proportion or the portion which has to be with the trust and which has to be with the outgoing trustee or whatever is the dispute, that can also be filed. Then authorizing the whole or any part of the trust property to be left therein shall to be left, sold, mortgaged, or exchanged. So what to do with the trust property? Basically, what to do with it? Shall it be sold or shall it be mortgaged, or how is it going to be given off? Okay. Then settling a scheme. If there has been a scheme of the public charitable trust, then how to settle it? Or granting such further or other relief as the nature of the case may require. Okay. So we will stop with this. We will go on with the continuation in the next series. Thank you.